Thanks very much, Professor Warren, for those words of invitation, and good evening, ladies and gentlemen. Thank you to each of you for coming along, as well, and in particular, Karen. It's lovely to see you, Karen. Just before I start, I want to just echo a couple of things that Warren said about Stephen. So, I was lucky. Stephen was a friend, so whenever Warren says he was funny and engaging and sometimes mischievous, always encouraging, always kind. So the priority for me tonight is to be able to speak on behalf or in memory of a friend. Stephen was a dear friend, as he was to John Morrison and Kieran and many other people, so we, of course, still miss Stephen. You also heard mention of Stephen as an academic, so I'm going to refer to some of his publications this evening, but so I'm talking about constitutional. Stephen was best known for his work in human rights, and probably, if I was to choose one of his books as his best book, I would say it was his prison law book with Tim Owen Casey. It's the exemplar of doctrinal analysis, academic analysis with a practical outlook. So it's genuinely an honour personally and professionally to be able to speak in memory of Stephen, and I hope that I say something of use and interest. I'll start with this book of Stephen. So this was a book that Stephen published with John Morrison. He's looking very quizzically at it. You did co-author this, John. This was a book, Reshaping Public Power, but really the key of it is in the subtitle, Northern Ireland in the British Constitutional Crisis, because this was published in 1995. Queen's produces frequently very impactful and important books, and this is one of them. This was a book that was very widely cited and very well regarded, because the essence of the book was a criticism of British constitutionalism at that time. So, very memorable phrase. John and Stephen talked about the dead hand of Dicey. As we're going to discover, actually, Dicey still has a bit of a fist and a punch when it comes to constitutional law. But it was a criticism of, if I can put it this way, almost a British obsession with institutions, with tired doctrines, with the imagery of, for instance, the Crown, and of old and tired processes. And it was a book about the need to reinvigorate democracy, go towards a more fluid idea of understandings of sovereignty, of the importance of rights, of values, deliberative democracy, and also, of course, the importance of European and international influences. This was 1995, and in 1998, of course, the Belfast Agreement represented just that type of constitutionalism in Northern Ireland. So the Belfast Agreement came along with north, south, east, west, local, international influences, European influences, rights, political equality as an emerging concept and grounding doctrine, and ideas of consociationism and power sharing. So Stephen and John asked for it in 1995, 1998. We got it at least on paper. So what I want to focus on this evening is sovereignty, where sovereignty takes form in the Belfast Agreement. I'm probably wrong in this. I'm happy to be corrected. I'm happy to be told there are other ways of looking at this. But there are 4 dimensions to sovereignty. There's certainly 3. The fourth one I take is a bit of a leap, but let me come back to that one. When we talk about sovereignty, of course, the starting point is statehood, territorial integrity, government with the power to make laws, government with the power to enter into relations with other states, and with international organisations. So we'll call that the statehood dimension of sovereignty, or you can call it the external dimension of sovereignty. It's about states being able to foster relations externally. Second one is popular sovereignty, which, of course, everybody will have heard mention of popular sovereignty. Certainly in Western liberal democratic systems, it's the role of the people in legitimating power within the state. No problem. Legitimating power within the state, so that may take form in the actual text of the Constitution itself. So I'll say something about the Irish Constitution 1937 in a while, the importance of people and nation and statehood in the Irish constitutional text. Can also take form in elections, can also take form in referendums, popular sovereignty. That grounds legal sovereignty. So again, if we take the Irish example, and we'll come back to it, the sovereign power to make laws is conditioned and constrained by the Constitution as interpreted by the courts. When we talk about the UK, we of course talk about the doctrine of parliamentary sovereignty, and almost an unfettered form of legal sovereignty, subject to arguments about the foundational importance of the common law. There's a bit where I get nervous, because this doesn't really exist, but indulge me. So it's an idea of executive sovereignty. Actually, Donald Trump is taking us very close to an idea of executive sovereignty. I suppose that's one point they made. But executive sovereignty Over the summer I read a book. There's a professor at LSE called Thomas Poole, and he wrote a book called Reason of State. It was published about 10 years ago. And it's one of those books you read it and you go, it's way too clever. It's just brilliant. It's an absolutely brilliant book. So Reason of State, it's linked into philosophy, political history, political theory. But the essence of Reason of State is that decision makers, there are certain decisions that have to be taken for the public good, in the public interest, for the safety and security of the state. And I think whenever you talk about reason of state, it almost goes towards an idea of executive sovereignty. So let me give you two examples. Look back up to statehood and international relations. That's the prerogative power in the UK system. It's pretty much a no-go area for the courts. It's pretty much a non-justiciable area of executive power. The other example I'm going to talk about is national security. I know that Kieran has been working on national security recently. When national security decisions are taken, of course the rule of law applies, but is it rule of law light, and how light should it be? And the lighter the rule of law becomes, does that then expand and inflate an area of executive influence? So those are the four aspects of sovereignty. Let me just say something about where they come into the Belfast Agreement. Statehood and international relations. Okay, the Belfast Agreement, most people will be familiar with it. If you're not, there are two parts to it. There's the multi-party agreement, and then behind that is the British-Irish Agreement. It's an agreement between two sovereign states. It was lodged with the United Nations. So the British-Irish Agreement is a commitment by two sovereign governments, the guarantors of the Belfast Agreement. In September of this year, the two sovereign governments also agreed upon a joint framework on the legacy of the Troubles. And I'm going to talk about that at the very back of the lecture, because actually when you talk about the legacy of the Troubles, I actually think that's where you start to find more of something approaching executive sovereignty, and it's executive sovereignty times two, because as we'll see, there are commitments on the part of the Irish government in relation to dealing with the past. Popular sovereignty. Those of us who were able to vote in 1998 had the option in parallel referenda to vote in favour of the Belfast Agreement. I was hoping I wouldn't have to put a bottle to my mouth, but I have. But when you talk about political sovereignty, popular sovereignty, the parallel referenda, at the time, was then increasingly talk about political equality between the two ethno-national communities in Northern, the two main ethno-national communities in Northern Ireland, and their linkages to Ireland and to the UK. That, of course, is synonymous with the consent principle, which I'm going to talk a lot about this evening. So the consent principle, for those of you who are not familiar with it, is the idea, it was central to the Belfast Agreement. Northern Ireland is a part of the United Kingdom, because that's currently the wish of a majority of people in Northern Ireland. If the majority wish changes, the consent principle means that steps will be taken to facilitate the unification of the island of Ireland. And of course, this is all over the news. It's a particularly hot topic. How do we go about facilitating a border pool in relation to Irish unification? Legal sovereignty, this is where it starts to become a little bit more complicated. So legal sovereignty, the consent principle puts Northern Ireland within the UK. So if you're within the UK, you're then within a system based upon parliamentary sovereignty. And if you're in a system based upon parliamentary sovereignty, you are query within a system based upon Dicey's imperial model of sovereignty. And that probably sounds a bit over-exaggerated, but you can't avoid Brexit in these presentations. And when we come to see about Brexit, it is an imperial model of sovereignty in the sense that it pulls power to the centre and it constrains and shuts off any other decision-making fora in relation to key decisions. That's the nature of Dicey's imperial model. Executive sovereignty, already said, it's really something to do with the problem of the past in Northern Ireland. You can open a book on how many times I'm going to use the word irony tonight, but one of the biggest ironies in the Belfast Agreement was that it didn't address the problem of the past pragmatically, because you couldn't address it, because we still haven't addressed it. So in the agreement there are some mentions of, for example, victims' rights, and that's something that's important. I'll talk about the Dillon case later on. But there was nothing structural in relation to dealing with the past at the time of the Belfast Agreement. And it has dragged on and on and on, and it has infected the legal and political process, partly because it's unavoidable, or issues of national security are unavoidable when you talk about dealing with the past. So that's where you get reason of state. That's where you get the joint framework on the legacy of the Troubles, and that's where executive sovereignty starts to look back up to statehood and, if you like, the external dimension to sovereignty. Now, there are some obvious ironies. We know all of these. There's one. We don't like each other very much in Northern Ireland, so we have two ethno-national groups. So we can talk about popular sovereignty as a nice idea. We talk about consent, but ultimately there are ethno-national divisions, and we've had staccato devolved government since the institutions were established in 1998. So, staccato is a phrase used by Lord Bingham, stop-start government. The political dispatches are at the moment, there are difficulties again. There's been a perennial stop-start process, and popular sovereignty is to be seen in that light. Some of the responses give rise to nice ironies, you could say, because if you're talking about political equality between the two ethno-national communities, the initial response to periods of political instability was dicey and direct rule under the Northern Ireland Act 2000. So just take power back to the Westminster government, put it under the direction and control of the Secretary of State, legislate by way of orders in council, and basically denude any broader understanding of the democratic settlement. It's basically a unionist settlement. I'll come back to that phrase, unionist constitutionalism, in a while. Another irony is more recently, for political reasons, there have been efforts to keep the institutions at least breathing. Between 2017 to 2024, I think it was, we had the institutions were sitting. Sorry, excuse me. The institutions were not sitting, but they weren't suspended. So, and you remember there were political debates about, well, why are politicians being paid when they're not actually fulfilling their tasks? This was an undemocratic and a technocratic system of government. The word undemocratic was used by the Northern Ireland Court of Appeal in the case of JR 80, which is referenced in parentheses. This is an undemocratic system of government. We had an undemocratic system of government that was trying to keep in place institutions, democratic institutions. Well, and that's ironic, I suppose. You might remember this was the executive formation legislation, so civil servants were allowed to make decisions in the absence of ministerial direction and control. Not all decisions, but some decisions. The Secretary of State for Northern Ireland was made subject to specific rule-making obligations in relation to same-sex marriage, in relation to provision of abortion services in Northern Ireland. Westminster would sometimes legislate, but otherwise things just drifted along. That was one of the consequences of our ethno-national division. And, of course, here's the biggest irony of the lot, which is Brexit. Because Brexit was an exercise in state sovereignty that discounted devolved preferences. That's Miller 1, the Miller case. You'll recall that in the Miller case, the issue was how is Article 50 to be triggered by the United Kingdom government, and there was a question about it. Essentially, did you need the consent of the devolved legislatures by means of the Sewell Convention? The Sewell Convention has a statutory footing in Scotland and in Wales, not an NI. And the Supreme Court said no, you don't have to. This is not an enforceable legal rule or a legal convention. It's political. The vote is a UK-wide vote, and therefore it's a decision for HMG to initiate the process of withdrawal. It also said the consent principle. There was an issue in the case about the consent principle, Northern Ireland being part of the United Kingdom or part of the United Ireland. It was argued in the Miller case by one of the parties that the consent principle meant there should be a vote in Northern Ireland because the process of Brexit would change Northern Ireland's constitutional status by shaving off EU membership. The Supreme Court was not attracted to that point and said no. It said that ultimately the consent principle is simply about the question whether or not Northern Ireland is in the UK or out of the UK. Anyway, now, those are, let's say, obvious ironies. These are the ones I'm going to talk about this evening in a while. I'm going to talk about three. So one is undoing the union from within without consent. So that's the Alistair case. Some of you will know the Alistair case. You'll be familiar with it. It is the Alistair case. There is an argument that the union is being undone from within by virtue of the operation of the economic elements of the protocol. We'll see that in a very strict doctrinal sense, Northern Ireland is still a part of the UK, but we can also see there are arguments which borrow from European integration theory about actually how the union is being undone from within without the consent of a majority of the population in Northern Ireland. A particularly interesting irony with that, of course, is that the structures that have put in place Brexit, and remember Brexit was about freeing the Westminster Parliament and repatriating sovereignty, a rebirth of parliamentary sovereignty, but one of the ironies of that is, because of requirements in the Belfast Agreement, the UK Parliament is still bound by EU law in certain areas. So we'll talk about that. I don't know why I keep we. I will talk about this. You will survive. And then the third one is the double bind of executive sovereignty, which is this issue of dealing with the past, where point number 2 feeds into point number 3, but there are 3 discrete issues. Now, which starting date? When you talk about sovereignty in the Irish context, which starting date do you take? And this is a quotation from Claire Pally. And Claire Pally used to work at Queen's. That's the best picture we could get. It's an article called The Evolution, Disintegration and a Possible Reconciliation of the Northern Ireland Constitution, published in 1972. And then Claire Pally said, well, most commentators succumb to an irresistible impulse to begin with an outline of the Stone Age in Ireland and then proceed with generous interlardings of opposite quotations to an account of current dissatisfaction. I only put that up because I didn't know the word interlardings. And I quite like it. I'm going to use it with every opportunity. Just not tonight. But anyway, as you're going to discover from the next slide in the first bullet point, I know about history. So you're going to get an exercise in potted history. So I'm starting... for Irish law, I'm starting with the Government of Ireland Act 1920. When I come to the Alistair case, I'll mention the Acts of Union 1800, but for the purposes of the Belfast Agreement, the starting point is the Government of Ireland Act 1920. Partition of the island, Section 3 of the Act envisaged an all-Ireland Parliament in the future, but that was quickly overtaken the following year by the Anglo-Irish Treaty, the Constitution of 1922. That then led to de Valera's Constitution in 1937. And the Republic of Ireland Act, 1948. Professor Casey, in his seminal book on constitutional, said that the 1948 Act was designed to show that 26 counties had left the Commonwealth and severed the final link with the British Crown. I mean, it was at the moment Ireland became a fully sovereign state, because that was the Act of 1940 gave the President powers in relation to international relations. Probably not, but anyway, those are the main stepping stones along the way. Now, the Irish Constitution itself, Article 1 of the Irish Constitution, 1937, the Irish nation still affirms its inalienable, indefeasible and sovereign existence. And by Articles 2 and 3, as originally within the Constitution, it proclaimed the national territory consists of the whole island of Ireland, its islands and the territorial seas, and that the reintegration of the national territory was a constitutional imperative. Constitutional imperative was the Supreme Court's words in the Magimsi and Ireland case. But de Valera's very muscular nationalist constitution, socially conservative, some have described as a Catholic constitution, but very muscular in its identification of the whole of the island as part of the national territory. So in other words, seeking to airbrush out Northern Ireland and the entity of Northern Ireland within the UK under the terms of the Government of Ireland Act 1920. Now, Articles 2 and 3 and the Belfast Agreement, the key concession and point from within the Irish system was modification of the language in Articles 2 and 3. So the rather muscular language of Articles 2 and 3, potentially even aggressive language of Articles 2 and 3, was watered down to make it much more aspirational. The unification of the island is an aspirational endeavour rather than something more controversial. And if you watched President Connolly's inaugural address on the 11th of November, she referred to unification. She referred to it as something that she desires, but she also referred to it as something that is tethered to the consent principle and the need for it to happen in a way that brings all parties with it. So that's now the logic of Articles 2 and 3. Now, Article 2 and 3 and the change, parallel referendum, said it was popular sovereignty. Some people have said, actually, with the parallel referenda, as a matter of international, that was self-determination on the part of the Irish peoples. That's an argument that Christine Bell and Kathleen Kavanagh, I think, is the name, made in 1999, or certainly explored. So, in Irish law, a proud sovereign state stepped forward at the time of the agreement, watering down the language in Articles 2 and 3 to reflect the achievement within the Belfast Agreement, the consent principle and political equality. Now, who's that? Sorry, Claire? Yeah, I mean, I looked. It has to be dicey. I mean, I hope it's dicey. I mean, I don't know. I mean, that's who came up anyway. Albert Venn Dicey, the great jurist, Victorian jurist. So when you go back to the Government of Ireland Act in UK law and NI law, go back to the Government of Ireland Act 1920 and Dicey's imperial sovereignty. One of Stephen's other contributions, he published an article where he talked about the Celtic nations as Dicey's nightmare, devolution in the Celtic nations as Dicey's nightmare. Because at the time of the Home Rule debates, Dicey was frenetic about the idea that there would be anything that would diminish the power of the Imperial Parliament. I'm going to bring up a quote from Chris, but Chris has written a chapter in the Cambridge Yearbook of Public Law, basically on debates between Bryce, not you Bryce, but James Bryce and Dicey about models of sovereignty. Bryce was more towards the idea of the possibility of federalism and that sort of trickling through the dominions and whatever. Whereas Dicey was very firmly, we can't go beyond anything other than a locked-in form of sovereignty at the Westminster Parliament. And that became the model of sovereignty that was in the Government of Ireland Act as applied to Northern Ireland. And I suppose, frankly, it's still the model that applies traced through the 1998 Act. Section 75 of the Northern Ireland Act 1920, the supreme authority of the Parliament of the United Kingdom shall remain unaffected and undiminished over all persons, matters and things in Northern Ireland and every part thereof. So this is a quote from Chris. So unionism, not political union, but unionism as the dominant constitutional discourse, this meant that unions leaving future generations of lawyers, academics and practitioners alike singularly ill-equipped to deal with later events. And Brexit is that best example. Obviously, this paper was published in 2015. Brexit happened after that. But Brexit is the great example that illustrates that point, because Brexit became an exercise in power hoarding at the centre. Power hoarding is the phrase was used by Anthony King in his very important book on the British Constitution in 2007. So the model of sovereignty that we were given in Northern Ireland was very much devolved, and it can be taken back in, but there's no element of sovereignty or shared sovereignty or pooled sovereignty. Sovereignty remains very much at the imperial centre, if you want to use that. It wouldn't be fashionable language today, but that would have been the language at the time. So power hoarding and the dominant unionist discourse. And of course it coincided in Northern Ireland with unionism as the dominant political power in Northern Ireland, or political unionism as the dominant power in Northern Ireland, the Stormont Parliament, and the very divided, controversial history that led into the conflict, which then led to the Belfast Agreement. Now, the Belfast Agreement in law, so I've already said earlier, the Belfast Agreement, there's the multi-party agreement and the British-Irish Agreement. So once the text of the Belfast Agreement was approved by the electorates, then the British and Irish governments moved towards other agreements in relation to North-South Ministerial Council, British-Irish Council implementation bodies. So that was a further exercise in state sovereignty. That created the architecture of much of the agreement, the interlocking strands of the agreement and the emphasis on other parts. I've put in brackets the EU dimension because, remember, of course, 1998, both the UK and Ireland were members of the EU, and in the British-Irish Agreement refers to them as partners in the European Union. And of course, if you're partners in the European Union, your sovereignty is limited by virtue of the membership. So sovereignty meant something, legal sovereignty was curtailed in a way that it's no longer, certainly in the UK setting, or not as widely in the UK setting. Consent principle in law, so there was amendment of Articles 2 and 3 of the Irish Constitution, which I mentioned above. It was written into Northern Ireland law by Section 1 of and Schedule 1 to the 1998, the Northern Ireland Act 1998. So whenever you're watching the news and there's a discussion about when's the Secretary of State going to put down the conditions for a border poll, that's a question about Section 1 and Schedule 1. That's the provision of Northern Ireland law that facilitates Secretary of State has a wide discretion. But those are the provisions that bring the consent principle and potentially activate a vote on whether there should be unification as a matter of Northern Ireland law. Hint of popular sovereignty again. Powers of the devolved institutions, so the Northern Ireland Assembly was set up by the Northern Ireland Elections Act 1998, but the powers of the Assembly, executive and legislative powers, they're contained in parts 2 and 3 of the 1998 Act, the Northern Ireland Act 1998. Part 5 deals with duties in relation to the North-South Ministerial Council and the British-Irish Council. That's sometimes in the news. There have been cases where, for instance, the UP ministers have refused to facilitate meetings of the North-South Ministerial Council and been found to have acted in breach of their duties. And the complex place of EU law is recognised under paragraph 3 of Schedule 2 to the Act, which was one of the issues in the Agnew case that went with Miller. Paragraph 3 of Schedule 2. So Schedule 2 deals with accepted matters under the Northern Ireland Act. International relations are an accepted matter. Northern Ireland Assembly and institutions can't go near it, but it says unless you're making decisions in the context of the North-South Ministerial Council, you can do it there. So EU law was interwoven into the Northern Ireland settlement in a large number of ways. Human Rights Act 1998. Another part of the Belfast Agreement was a commitment to rights in the European Convention, being part of Northern Ireland law. So the ECHR was incorporated into the Human Rights Act. I put that in because, of course, there's a lot of discussion now about the UK withdrawing from the European Union. Of that sovereign act of statehood, well, what would that mean in terms of Northern Ireland? Because there's a firm commitment in relation to the in relation to the European Convention under the Human Rights Act. So the Belfast Agreement was taking its shape around, let's go back to John and Stephen's book from 1995, the idea of a more nuanced idea of sovereignty and power. That's what was taking shape around. But take a wee peek at, for example, Section 5.6 of the Northern Ireland Act 1998, which reaffirms the Dacian principle of the sovereignty of Parliament. So you had Section 75 in the 1920 Act. Section 5.6 comes into the Northern Ireland Act. The sovereignty of the Westminster Parliament is expressly safeguarded by Section 5.6. And of course, the doctrine of the sovereignty of the Westminster Parliament also underpins the scheme in the Human Rights Act ultimately. So it's not possible to strike down legislation under the Human Rights Act, and that's one of the differences under the Human Rights Act compared to EU law. We'll see that later. So that's quite a lot so far. The ironies. I'm going to bring up a couple of pictures just to try and break it up a bit. I went onto the internet just to find those pictures. Normally Nigel Farage has a sort of a faux-friendly smile and laugh, but that's quite an aggressive picture. But that's not the purpose of it. I wanted to find pictures of all these key characters because they're actually relevant to some of the points that are coming later. So I found pictures of all of them pointing, frankly. So that's Hilary Benn. He would be a less aggressive pointer. Mary Lou MacDonald. I had tremendous difficulty in a picture of Mary Lou MacDonald because one of them was obviously a copyright infringement, so I better take that down. And in another one, she was pointing, but very aggressively. I thought, well, I can't have that, so that's a more innocent point. And that's Jim Allister. I hope none of Jim's friends here, but he does look like he's singing in that one. Anyway, so I brought up these four pictures to try and break the mundane nature of listening to me talking about sovereignty, but also because as politicians or as office holders, they're relevant to the points that I'm going to make in the remainder of the lecture. So, Allister, let's start with the Allister case and the Ireland-Northern Ireland Protocol on doing the Union from within. One of the ironies of the agreement is that the consent principle has meant not a lot in the context of Brexit, where the sovereignty of Parliament has meant that the Union has been undone from within. Query. What does the Protocol Now Windsor Framework do? And I do have to, one point, always read things closely, because the Windsor Framework was refashioned as the Windsor Framework whenever there were very concerted political attempts to try and get unionism on board. And the first time I read it, I honestly thought it said the Windsor Park Framework. So that would, so the Windsor Framework. The protocol, as amended, it's quite a short document in terms of the text. The appendices add something, but it's very complicated. I'm just going to reduce it to a couple of very basic points for the points that I want to make this evening. If there are issues arising, questions, I can try and find them in the recesses of my brain. So, what does the Protocol Now Windsor Framework do? Well, it's meant to be. So, if you look at Article 1, and I think maybe one of the paragraphs in the preamble to the protocol make its point. It's meant to be without prejudice to the Belfast Agreement and the principle of consent, and that is specifically stated in Article 1. So the protocol is not meant to change Northern Ireland's place within the United Kingdom. However, it also seeks to avoid a hard border on the island of Ireland. And Billy, please help me if I've got this badly wrong, Billy. This one? Yeah. Therefore, it keeps NI, in a nutshell, it keeps Northern Ireland in the EU's internal market in goods and its customs union for as long as the provisions of the protocol remain in force. And really, those words at the end are the key to the way in which the courts have dealt with it here. For as long as the provisions of the protocol remain in force. Now, with the Windsor Framework, there were, before the Windsor Framework, there were endless problems. And the UK government was essentially saying we're not even going to try and give effect to the terms of the protocol because there wasn't the infrastructure to do it. The Windsor Framework tried to dilute some of the points, but Northern Ireland still remains within the EU's internal market in goods and as customs union for the purposes of the protocol. It also, and this is a key point for understanding the limits on Parliament's powers later, it also maintains the full suite of EU law's doctrines in cases of fall under the protocol. Or certainly under these provisions, the Court of Justice doesn't have a role in relation to all of the protocol, but the principles of EU law applies. So the supremacy of EU law applies in cases under the protocol. Direct effect applies under the protocol. Frankovich liability applies under the protocol. Effectiveness, so on and so forth. So you can go back to your EU law studies, think of the main principles. They are locked into the protocol. That's the intersection of Article 4 of the withdrawal agreement, and I think it's Article 12.3. It's either 12.3 or 13.2 of the protocol. They come in to the domestic system and are locked in as a part of Northern Ireland law. So, in the Alistair case, the first point that was really raised was about the effect of Section 7A of the European Union Withdrawal Act 2018. So, the European Union Withdrawal Act 2018 started the process of withdrawal when the withdrawal agreement was agreed in 2020. The European Union Withdrawal Agreement Act 2020 amended the 2018 Act, and Section 7A became the key provision. In Section 7A, those of you who've studied EU law, certainly from the same sort of vintage as I am, will remember Section 2.4 of the European Communities Act. It's essentially the same sort of provision. It's a catch-all provision, and it says, without having to do anything more, in terms, without having to do any more, the protocol becomes a part of domestic law, and any legislation which has been passed or made before the protocol or after the protocol is to be read in the light of the protocol. That's the effect in summary form of Section 7A. Section 7A. Now, the central issue in Alistair, there were more issues in this. I'm not going to put them all up because it would be far too much detail. The central issue for the purposes of this evening's presentation was whether the protocol was consistent with Article 6 of the Acts of Union 1800, whereby, among other things, His Majesty's subjects of Great Britain and Ireland shall be entitled to the same privileges and be on the same footing generally in respect of trade. So Section 7A brings in the protocol, but Section 7A cuts across Article 6, or the Supreme Court accepted that it created an inconsistency without it made the presumption there was an inconsistency. Now, the argument that was made by Mr. Alistair and his co-applicants was, if Section 7A, or the protocol that comes in under Section 7A, is not consistent with Article 6, that affects Northern Ireland's place in the Union because the trade structures that apply in GB and NI are not the same, so that affects the arrangements, and they say that changes Northern Ireland's position, and that could only have occurred with the consent of the Northern Ireland electorate as per Section 1 of and Schedule 1 to the Northern Ireland Act. In its own way, Alistair it's the greatest constitutional case it never was, because the Supreme Court adopted a very straightforward approach to the issues. It's a short judgment. If you look at the Court of Appeal judgment, it's a long read, and there are two judgments. The Supreme Court judgment is very short. And there are two possible approaches to that issue. Now, the Supreme Court is the orthodox constitutionalism approach, and the Supreme Court is right about things, isn't it? It is the Supreme Court, so I mean that's the formal position in law. But there's also, as I said, I flagged up earlier, there's an economic constitutionalism type of approach to it, and I'll come back to that. On the orthodox constitutionalism point, the Supreme Court, Lord Stevens, who's the Irish law lord, he delivered a judgment of the court, and there were arguments before him about constitutional statutes and can there be implied repeal or it must be express repeal, and the Act of Union and the 2018 Act in the Northern Ireland. Lots of interesting arguments, but Lord Stevens basically said, I mean, don't waste your time becoming excited about this, because the language of Section 7A is perfectly clear. Section 7A brings in the protocol. All other legislation is subject to the protocol, and that's the position while the protocol remains in force. So he said, Section 7A modifies Article 6 for so long as the protocol is in force. So he said, if the protocol changes or something happens and it doesn't, then Article 6 will go back to its original terms, just modified for the duration of the protocol. I mentioned the word modifies because In the Court of Appeal, the Lady Chief Justice had used the language of the Act of Union being subjugated to the Protocol, which was a slightly more difficult phrase. Or as Lord Stephen said, no, it's a modification. That was the language that had been used by Lord Justice McCluskey in the Court of Appeal. So he said, look, don't worry about it. Dacian sovereignty, he referred to a Dacian model, the power of the sovereign Parliament, Parliament's intention, Section 7A, it overrides it for as long as the Protocol's in force. What could be more simple? He also said the consent principle is not engaged. The argument, a very short section in this, he said, in Miller 1, the Supreme Court said the consent principle only applies to the question of whether or not Northern Ireland is part of the United Kingdom or is to become a part of the United Ireland. That question is not an issue here. The Protocol doesn't change Northern Ireland's status as part of the UK. Now, so that's the orthodox approach, the Dacian sovereigntist approach, if there's such a phrase. Economic constitutionalism. Now, this is flying a kite a little bit, but it's just to think a little bit more laterally about actually what happens as a result of the Protocol and linkages within and outside the state. So economic constitutionalism, associated with the origins of the EU project itself. Very famous book by former Advocate General Miguel Juarez Maduro about the economic constitution, economic integration, the treaty provisions, the integrationist jurisprudence of the Court of Justice. And the argument of this, it's things like, I mean, going way back, things like functionalism and neo-functionalism, these sorts of contributions to literature on the economic European project. You start with economic integration, that leads unavoidably to deeper political integration, and deeper political integration leads to constitutional integration. Now, the argument that you would then make about the Protocol, and I suspect this is the argument that was being made by the applicants, is once you link Northern Ireland in more fully to, let's say, all Ireland economic structures within the framework of EU law, once you do that, that starts to create path dependencies. With a period of time, economic modelling fits together. If there's any change to the Protocol, there's a duty of dynamic alignment. It must be traced. Okay, Windsor Framework adds something on a new Article 13.4 thing. But basically, once you trace it and you create these path dependencies, that starts to assume a logic of it, and it creates deeper links. Brackets would at ease unification because there are already economic structures that would complement a process of unification. Look, you can't really measure it, but it's an argument. Now, as against that, people would say, well, no. The UK Internal Market Act 2020 is a counterbalance to this. The UK Internal Market Act 2020 includes provisions whereby Parliament has expressly said you must have special regard. It's almost special regard on stilts in relation to Northern Ireland's position within the UK's market. Parliament has therefore clearly tried to prioritise Northern Ireland, but it doesn't change the fact of the workings of the Protocol. And when you look at free trade agreements, I have to thank Billy for this. Billy sent me an article he's written on free trade agreements and highlighted this for my purposes. When you look at free trade agreements, so we hear about global Britain. So there's never a global United Kingdom. There may be a reason for that, because global Britain doesn't really include Northern Ireland in quite the same way. Because if you look at the free trade agreements that are being signed, they include a little carve-out provision that says Northern Ireland's a bit different. Okay? There's an example. So that's, I've taken that from Billy, so I'll acknowledge that, Billy. I'm not, no, in case I get in trouble for plagiarising. But this is from the UK-Australia Free Trade Agreement. For as long as the Protocol is in force, that phrase again, as long as the Protocol is in force, nothing in this agreement shall preclude the United Kingdom from adopting or maintaining measures or refraining from doing so further to the Protocol. So there's a free trade agreement between the UK and elsewhere, but it's a free trade agreement more immediately between GB and elsewhere, because the Protocol is a bind on the UK government and the Protocol has to be preserved, and the free trade agreements specifically acknowledge and recognise that fact. Now, go back to the points from Alistair. It does look like some sort of change in Northern Ireland's status, certainly its economic status, and is that one of the ironies of the Belfast Agreement, because the sovereignty of Parliament has undone the consent principle and started to undo the Union from within on account of economic consequences. Anyway, who knows? The remaining irony, so probably about another 10 minutes, so if you want to set your stopwatch. The remaining ironies are both related to the problem of the past. So I said at the outset of my lecture that the problem of the past wasn't addressed in detail in the Belfast Agreement because you couldn't address it. It's so complicated, and it's still going on as a source of difficulty. So what we're dealing here really with is the problem of the past, and it's the Dillon case. Now, the Dillon case it was in the Supreme Court in October. It was almost like Succession. People were saying, "Did you see the second day of the Supreme Court?" You can watch it on TV. Oh my goodness. But the Dillon case was heard in October. So what I'm going to say about it this evening, which is pretty short, but it may all be overtaken by the Supreme Court ruling. The Supreme Court will deliver judgment presumably in February or March, would be the usual sort of timeline. But in the Dillon case, this was a challenge to the Troubles Legacy and Reconciliation Act 2023. Now, you may remember that was introduced by the previous Conservative administration, and I don't think it's unfair to say the Conservative administration had basically had enough of dealing with the past. In Northern Ireland, there were issues of expense, there were issues of difficulties in the court system. The government was concerned about the treatment of veterans, thought there was vexatious prosecution of veterans. So they said, right, we're going to draw a line under this piecemeal way of approaching the past. We're going to introduce the Troubles Legacy and Reconciliation Act. So it introduced, Kieran knows much more about this than I do, so if there are any difficult questions, Kieran will deal with them. Dealt with immunity from prosecution, so people would not be prosecuted under certain circumstances. Cessation of inquests that weren't finished by a particular date, they would be brought to an end. And there's a creation of an independent commission for reconciliation and information recovery. And it was going to basically replace all of the ad hoc processes that have been going on and become, in essence, a one-stop shop for dealing with the past. So there was a focus in it, and I know that Chris was involved in this in the Supreme Court. There was a focus on it on Article 2 of the Protocol. I didn't mention Article 2 of the Protocol earlier, but I'll mention it now. So what Article 2 of the Protocol basically does is first of all, it says there to be no diminution of rights within the Belfast Agreement that are found in the rights, safeguards of opportunity and equality section of the Belfast Agreement. And if you go to the Protocol, Article 2 then, it appends in an annex, I think it's Annex 1, it appends 6 non-discrimination directives that are found in EU law. But it also refers to this part of the Belfast Agreement which makes mention of, for instance, civil rights. And lists some suggest right, but refers to civil rights. And the essence of Article 2 is when the UK withdraws from the European Union, there is to be no diminution of rights that are underpinned by EU law, so it could be the directives, obviously, but also any rights that are found within the rights, safeguards of oh God, I can never remember. Anyway, the rights section of the Belfast Agreement. Any of those that are underpinned by EU law, they can't be diminished. That's there's a 6-stage test from the Spuck case, which is discussed in Dillon on the sequence we're going through. But basically, you can't go beneath a right that was protected by EU law after Brexit. There was also a focus on the law of the ECHR, the European Convention on Human Rights, as applied to the work of the ICRIR. And I'm sorry to bring in another article too, this confuses things. There were concerns in particular about the Secretary of State for Northern Ireland's role in vetoing the release or disclosure, that would be better, not release, disclosure of sensitive information by the ICRIR. The Court of Appeal said this was in breach of the investigative obligations of the state under Article 2. Now, here's the irony, which is the bind to EU law. And I have to confess, when I read the protocol for the first time, not that I'm a harbinger of anything, but I did not for 1 second see that the Westminster Parliament was going to be caught by the primacy of EU law. That either means it's very, well, probably means I'm a bit stupid, frankly. Anyway, the Court of Appeal said that the immunity provisions of the Troubles, so the idea that people would not be prosecuted, The immunity provisions of the Troubles Act breached various provisions of the EU Victims Directive, as was read in, there we go, easier for me now, as was read in the rights, safeguards and equality of opportunity section of the Belfast Agreement. So it came within the rubric of civil rights within the Belfast Agreement. The Victims Directive is reflected in the Victims Charter that's used by the Public Prosecution Service. It allows you to request a review of a decision, not to prosecute. That, amongst other things, of course, well, if you take away the opportunity of a review of a prosecution, that's diminishing rights that are protected under EU law, or civil rights that are protected or underpinned by EU law. And they said that was contrary to Article 2 of the Protocol. So this is the interesting point. The offending parts of the Act were thereby to be disapplied in accordance with the factor principle. Factor that most seminal of all British constitutional cases to do with UK constitutional law, disapplication of an Act of Parliament that breaches EU law. And in this case, the Court of Appeal said the offending provisions are to be disapplied in accordance, in essence, with the factor principle. As above, EU law enjoys supremacy under the Protocol. Where this became interesting, I suspect, I wasn't at all involved in litigation, so I don't know, where this perhaps then started to attract the interest of the government was, if you're just dealing with the legacy issue in Northern Ireland, that's pretty much an Irish-specific issue. Let's call it almost island-specific. But in that case brought by the Northern Ireland Human Rights Commission, there was a challenge based upon aspects of immigration law, and Mr. Justice Humphreys found it was a diminution of rights protected by EU law in the immigration sphere. And I suspect probably at that stage the government went, that's not just Irish-specific, that's UK-wide potentially, and there have been other cases as well that are raising issues with UK-wide implications. So that's probably a motivator for the appeal that's been brought. I know the government's not appealing the finding about the immunity provisions, but there is an appeal on the Article 2 framework more generally. The point about legal sovereignty, I'm sorry to put that quote from The Sopranos, but it's one of those things. The Parliament's just when I thought it was out, you're brought back in and you're bound by EU law again. EU law is supreme. Now, the Supreme Court may say it's not. The Supreme Court may say Article 2 doesn't have direct effect or whatever. There may be some way in which the Supreme Court works around this, or the Supreme Court may say the Court of Appeal was entirely correct and there is a bind to EU law, and whilst the protocol is in place, these issues have to be dealt with on a case-by-case basis and in the light of the policy issues arising. The last point is Dillon, national security and reason of state. So this is the role of the Secretary of State in basically preventing disclosure of sensitive information. So the key provisions in this context were in Section 30 and Paragraph 4 of Schedule 6 to the 2023 Act. And I'm sure this is a gross oversimplification, but let me do it for the purposes of getting this over the line and finished. In essence, the Secretary of State could prohibit the disclosure of sensitive information and also refuse to give reasons for his or her decision if the giving of reasons would prejudice national security and there are only limited review rights. So the Secretary of State had, the Court of Appeal found the Secretary of State had very broad powers in relation to the non-disclosure of evidence. Now, it's a complicated area, and I looked at, if you're interested in this, you can go on and you can get all of the written arguments that were in the Supreme Court, and you can go to the government's appeal and you can see the way in which this issue has been set up by way of appeal. It's not straightforward. I couldn't possibly pretend I could explain it. But the Court of Appeal looked at this question of the government essentially invoking national security. That's essentially what the government is doing. It's invoking national security. The Court of Appeal looked at this and looked at what had happened in coroners' cases, PII cases, so public interest immunity in the context of coroners' inquests, and talked about the role of the High Court in judicial review proceedings. Before I got those conclusions. Now, in parentheses, you'll see a reference there to the Thompson case. That's a decision of the Northern Ireland Court of Appeal from last year. And if you go online, the Thompson, it'll tell you something. The moment you open it, it'll tell you something, because it's only the open part of the judgment that is there. So it's Lord Justice McCluskey dissenting. The rest of the judgment is dealt with. It's closed material. There are closed judgments. You will not see them. Thompson was a case in which a coroner had essentially overruled the Secretary of State on the question whether or not PII should attach to particular evidence. So the Thompson case is before the Supreme Court. I had actually thought it might have been out this week. Apparently it's imminent. But in Thompson, there's going to be, I would imagine, a pretty exhaustive judicial analysis of the respective roles of ministers lower courts, review courts on questions of national security, who should look how closely at decisions about whether or not national security considerations are engaged. So the Court of Appeal, anyway, the Court of Appeal looked at this issue, the provision said, well, we have the coroner's courts and public interest immunity certificates. We have the role of the High Court in judicial review proceedings. And of course, if you talk about this, you also go towards what are called closed material procedures. So the closed material procedures were used. There would have been certain scenarios where public interest immunity was becoming so much of a problem that the case couldn't go ahead or whatever. There were limitations of what the common law could achieve. So legislative intervention allows there to be entirely closed courts, if you like, dealing with difficult national security issues and special advocates and so on and so forth. I mentioned the Brown case. The Brown case is worth mentioning because it's the very tragic case of Sean Brown. And that's gone to the Court of Appeal. Sorry, that's not a correct citation. Re Brown 2020, that should say NICA 16. That's the case of Sean Brown because a coroner's inquest was bedeviled by PII requests, and then the High Court ordered an Article 2 compliant public inquiry, so that's potentially going to the Supreme Court as well. Anyway, Court of Appeal said this is the way the law fits around these things, and when we look at what is happening here, the Court of Appeal ruled that provisions in the 2023 Act offended Article 2 of the European Convention on Human Rights. So that's not Article 2 of the Protocol, it's Article 2 of the European Convention on Human Rights. The right to life, there are investigative obligations and duties imposed upon the state, including independence from state actors, and the Court of Appeal said Article 2 is not met on the facts of this case. Now, the part of Mr. Justice Colton, as he was at that time, he had said in the High Court, actually, there is no breach of Article 2 here. The Court of Appeal disagreed with that, and that point is, again, before the Supreme Court. This takes me to the joint framework on the legacy troubles. This takes me to my last slide, you'll be pleased to hear. So, the UK government has since introduced a bill, the Northern Ireland Troubles Bill, which is repositioning some of the things in relation to the issue of dealing with the past. So the ICRIR is going to be refashioned as the Legacy Commission, and inquests can start again. Inquests that hadn't completed that were running can be restarted. But Schedule 5 of this deals, it's a bill so it may change, but Schedule 5 of the bill deals with sensitive information and appeals against decisions of the Secretary of State, but it specifically references the High Court applying the principles applicable on an application for judicial review. And that's why I said Thompson again. You should keep your eyes open for the Thompson judgment, because Thompson may come out with a very, very conservative judgment and say the role of the court in national security issues, the court's never going to say it's non-justiciable. You say it was non-justiciable, but they're going to say on the question of reviewability of a decision, the court really should take a very light touch review. And if a court starts to take a very light touch review, that's where you get towards this idea of reason of state, because government ministers, taking that example, will be saying there are particularly acute concerns of national security here. Does a court then step back and say, well, we're limited to Wednesbury review, and Wednesbury assumes a different sheen if you're doing the national security cases? They may not say that, but Thompson may pull back from it. It also referred to appeals being heard under Sections 6 to 14 of the Justice and Security Act, so it's closed. The way I read it is, I may be wrong, so you bring an application for judicial review. It's not going to be an open court, it'll be in a closed court under the 2013 legislation, which takes things out of public gaze. I may be wrong in that. I'm happy to be corrected. The other interesting thing about the joint framework, so the government said in the joint framework we're going to put a bill before Parliament, we're going to change these things. But the other interesting thing is the Irish government has committed itself to establish a dedicated unit within the Guards and to legislate, and this is lifted from the joint framework, legislate to enable the fullest possible cooperation. That's a great phrase, the fullest possible cooperation. Not possible cooperation isn't possible. But the fullest possible cooperation of the relevant Irish authorities with the Legacy Commission, and on the same basis, in the same spirit, the UK authorities will provide reciprocal cooperation to Ireland, so to the fullest possible extent, reciprocal. Now, I genuinely don't know, I don't have any insight in Irish law at all. I spoke to a friend who's practiced in the Special Criminal Court, and he was of the view, well, like national security, of course, it's a feature of Irish law. There's a book published by Hart in 2019. But he said it's not developed in the same way and to the same extent as it has been within the UK system. But he was of the view that if there's going to be legislation of this kind is presumably, because when you go to the fullest possible cooperation, is presumably going to include some sort of national security override for the Irish government. So there will be, the idea is there will be an exchange of information, but not if there's a national security reason not to do that. And I do wonder if, what that looks like, do you then start to have a reason of state times two in relation to dealing with the past? Because you will have the law on national security in Northern Ireland, and you'll have the law on national security in Ireland. And I'll finish by making this point. We do know, so the Commission should run for at least 5 years, it may be extended beyond that, and we know that we have elections coming up somewhere down the line in Ireland and in the UK, and we know from the projections, the polls at the moment, you could have a member of Sinn Féin who's a Taoiseach, and you could also have Nigel Farage as the Prime Minister. So the ultimate irony may be that reason of state will befall Mary Lou MacDonald and a very angry-looking Nigel Farage. So anyway, that's pretty much me. So thank you very much indeed.